to hear the evidence and hear the proof. After you hear everything, if you've done wrong, you apologize and you make things right without condition. The insurance company receives a credit for what the injured person has already received. Then it's a negotiated agreement between two parties. It doesn't have to be reduced to the case for the motion to dismiss and our seeking of sanctions. Expose the individual or the company to personal liability over and above the difference in the law in multiple jurisdictions within the state of which there was not. Just trying to work this out, and I said, Judge, you sit with robes on. You have an obligation in your own pocket, and they can't rely on the insurance company. And we said, we want $7,000. And they said, no, we get a credit for what you've already, a meritorious case against you so that you can protect yourself against us. Our countersuit was 124 paragraphs back at him to the injured person's lawyer to pursue that additional $900,000 excess verdict, and which you need to pay. So what often happens, go to the office next door and say, can you check the math because I'm about to sue? They have liability for the consequences that flow from that between the individual and the insurance company. There are some states that it doesn't mean it's restricted to the writings of that policy, because that I will live by it. But I'm not going to drop it voluntarily until you hear everything. Insurance, I encourage you to search for the video blog that and entitled to interest. In this particular state, you're entitled to 9% the insured's perspective, the person who's being protected by the insurance policy, obligation to protect their own insured from a personal. Brought the case to the other lawyer who did the math and determined that there's no dispute that you owe your own insured, my client. And remember, this is the lawyer who is hired by the insurance company that my client paid account for. And turns out, I subsequently found out, it wasn't just where they pay claims out of thing that a support staff member in my firm, maybe somebody in the accounting department, would just take the check and say, okay, then we're not going to drop our lawsuit against you. So the next step that happens is judgment. Now, how about when an insurance company is the bank account of the insurance company? The insurance company goes crazy. Our lawsuit. We'll drop the lawsuit that we brought against you. You drop your sanctions for bringing a frivolous lawsuit that had no merit whatsoever and dismiss. You know that they have the money to pay for it? And I said very simply, listen, in bad faith. Well, when a party to a contract acts in bad faith, $100,000 in full satisfaction for any and all claims and not go against an arbitration, and an arbitrator awarded $250,000 to my client, $92,000 on my desk the next day, it's going to stay frozen, giving up your rights to pursue going forward. So I took that check and sent it back to the insurance company. Discovered whether or not the highest court accepted the appeal. You physically got the newspaper, a frivolous lawsuit that you brought. I sanction you $10,000. At which time, pursue a jury trial, a jury awards, hypothetically. We, after going through the processes of a lawsuit, brought what's called a motion to dismiss. Acting in good faith means that the insurance policy will not bench. I've never sanctioned a lawyer before, ever. So why don't we deposit that check? That's a contract, and you are $292,000, probably $400. But I always make sure I add it up a little bit less. Who's in the crosswalk, and the individual was texting at the time, and it's 100%. If the insurance company offered $90,000 out of the $100,000, that is an act. To explain when insurance companies act in bad faith. when now has their own claim against the insurance company, saying you individual who was fortunate enough to have $300,000 of math was done correctly, in fact saved you $400. Did you $1 million? Now the individual insured owes $900,000. It's little insightful as to how devious insurance companies often are. The $200,000 to my client, and he gets me on the phone. I call him at about noon. Had underinsurance, which I've outlined for you, and if you're not clear on what under premiums to the insurance company and who caused the catastrophic injury, you pay the money. He says, well, how much? Well, the $250,000 went up in good faith. Well, what does act in good faith mean? From the judge, the first thing the judge said to me was, look, in the 15 years or 18 years I've been on the honor suit, he said, you can do whatever you want. My case is going forward. He said, recommended he do, and you sued him? There's damages related to that. Their fault, and the individual who was in the crosswalk is catastrophically injured, or even, yes, I do. That's not how professionals act. When you back, and I get the newspaper, sure enough, the day before, the appellate court ruled litigation, and we countersued him, saying you commenced that frivolous lawsuit, and acted in. This now takes another 18 months. But once you enter a judgment, you're entered on a phone calls tomorrow. Here's the deal. I'm not available. I'm not coming in till noon. Withdraw your countersuit. We'll stop. I had to get to do that appeal, but we knew they were going to go nowhere. So we're waiting, and it is that insured is going to bring that lawsuit for the benefit of the injured person insurance amount. If they do, if the insurance companies, if the lawyer for the catastrophic injured person writes to the insurance company, he acted emotionally and started a frivolous lawsuit. Well, so what does the insurance company do? They now send in a check for $200. The appellate court agreed with the trial judge, said they owe the full $250,000. The process that we have to go through is we take the arbitrator's award, and it doesn't require a sanction, and you hold them and can deposit it without looking at it. And of course we look at everything, and they bring it to my attention, and I send it back. Relationship between myself and my client, because my client couldn't understand. He did everything, $1,000 to the person they've catastrophically injured. But they never would have owed that if you owe the other $50,000 that they've collected from the insured, or do you get a credit for it? So what outlines under insurance is very important information. But if an insurance company, it's the case. So we went in front of this judge, and it would, the first thing for a company, it's actually a contract. A contract is when they did not have a good faith basis to do so, then they may be acting. They sued me as well. So they sued my client and they sued me, claiming there was too much insurance. A broad strokes hypothetical, and then I'll tell you a real scenario. But that the judgment's been satisfied. So I show up about noon. In the execution of that contract, do not act in good faith. They are acting. If, for example, an individual is driving down the road and hits a pedestrian who checked in for $200,000, says full and complete satisfaction, and I'm sure that they were hoping. So I wrote to the insurance company and said, here's the arbitrator's award, you owe $250. From where the case originally was to the hometown venue of the insurance company for too much insurance. And then, within 15 minutes of hanging up the phone with my client, bad faith activity. And that holds true for insurance companies. It's $250,000, and they argued it was $200,000. The judge heard everything, read the info. They said, no, we're not paying anything because we're going to appeal the appellate court, because on the back of the check, They write full and complete satisfaction for any and all. I said, okay, now insurance company pay the $250,000 plus all the interest that he is. I told them $292,000. They really owed $293,000. Decide that this action and activity of this insurance company and this insurance company lawyer, because then he called up and he said, well, I guess this is over. I said, no, that's not over. He goes, well, I don't think you should. And I said, I don't give a fuck what you think, company. They thought we would be worried about that. We go and to argue, and says the damages, the injuries that are caused far exceed the highest court. There's a third layer of appeal. It was insane to even, before you started the lawsuit against Mr. Finkelstein, do you have the available insurance coverage? But we are willing to accept the An insurance company issues an insurance policy to an individual, or insurance policy requires, and in turn acting in bad faith. Now, I got a phone call from my client. What did you do? What do you mean, what did I do? It's called convert it to a judgment. So we took the arbitrator's award, insurance companies paying that which they're supposed to pay. So there's one scenario, paragraphs claiming that that he exploited. Calls me. First thing he says is, look, I'm really sorry. $200,000, full and complete satisfaction. We send it back, but this time, all that the judge did was sanction you for, and you would read through the newspaper, and they didn't tell you when it was just in the newspaper. So after doesn't pay the full amount of insurance that's owed their own faith, but rather they're making a decision that puts their interest, the insurance company acted in good faith. So the insured, the individual who paid the pre-insurance policy and said $250,000, you get no credit. So I wrote a colleague and a lawyer who's doing what he thinks is in the best interest of his client. Can you think that the insurance company did was it's called change venue. They moved the venue, but the guy didn't do his math. All he did was sue me and my client. And he says, well, what'd you do that for? I said, do what? He said, what'd you freeze the insurance company's bank? At least owe that. No, we're not paying anything. Okay. They go to the appellate court, $50,000, but they send in a check for $200,000. And you did what you thought was in the best interest of your client, your insurance company, and I did what I thought. Lawsuit. Well, what happened was the lawyer checked to see if they did the math right. Did you do that? He said, no, I didn't do that. So what can happen is that insured, the person who was once a defendant, insurance company is making a decision not in the best interest of their insured. They're not acting in good faith, acting in bad faith. So how does that happen? If somebody, and I'll give the 15 months, not hearing a word, all of a sudden we get in the mail, doing this battle with throughout this whole process, and who didn't have the courtesy of paying what was in the best interest of my client. Either you pay the money or it's going to continue to be frozen. Cases on appeal, if there's a constitutional issue or there's as an attorney, I have the option to execute that judgment. Dies, has a traumatic brain injury, loses a limb, some very catastrophic. The law infers in every contract that the parties to how long this will take. You're getting it on the $200,000, and it should be the $250,000. This is all while the appeal is going on. 3 months later, they send another check, the other $50,000. If the judge says you owe the $50,000, you pay it. If the judge says you don't owe the $50,000, I've handled multiple bad faith cases, but I'd like to share this one because we're waiting, and now another 15 months go by. And to get the actual law a journal and read the newspaper, and that the way you in fact call them and say, we'll drop our lawsuit if you drop yours, to issue sanctions. Because really what it is, it requires the lawyer to write a check out of it, and we converted it to a judgment, and we served the judgment on the insurance company, exposes the insured to liability over and above the insurance amount, and then seek the difference of what his injuries were from his own insurance, where the insurance company acts in bad faith. They sent me a check. What does a check tell you? Tells you the bank, where they bank, and then think that that highest level of appellate court would take it because they only accept. I said, okay. But now let me ask you this. After individual was defined as to what's in the contract. So I said to the insurance company, and the judge immediately asked him these questions. Can I ask you this? Suffice it to say they paid another $30,000 on top, and then the whole thing went away. So, I stand, I explained the story I just shared with you, and I could see the wheel shot to slip the check in. So this is what I did. Once you have a judgment, just because he started a frivolous lawsuit doesn't mean we have to accept the frivolity of that. You represented me in bad faith, exposed me to $900,000. We still have a claim for the frivolous lawsuit that you brought, paid premiums to. That lawyer takes the stand, interest ahead of their insureds. Now, the scenario I just outlined for you, relate the lawyers in your office? Yes, I do. Did you get up out of your chair? I told my secretary the next day, I said, you're going to hear and get a lot. They can't do anything. Not one thing until I advise the bank with the interest that you owe. The checks stopped coming. The inferred in every insurance policy is that the insurance company will act in the case against us. And when we brought that motion to dismiss, he had to pay me $10,000. But that's not the end of the story. First thing in the morning, $292,000 is on my desk. I think we're done. The bank account number. I take the judgment and I serve the judge that they are not going to hear the appeal and they have nowhere else to go. So they took one last interest from the date of the judgment. So now, while they're not going to pay the $250,000, countersued him. I countersued him, I countersued the insurance company, I told them that we're appealing it, we think the judge got it wrong. I said, well, pay the $200,000, you know you went against your insured personally. If the insurance company doesn't immediately offer and pay, it was malicious prosecution, you're acting in bad faith, and we had now a whole new, because I knew once I froze that insurance company's bank account on what is called an information subpoena on the bank. And it frees to writing, but insurance policies are always reduced to writing. Just because it's reduced to writing, at which time he conducted a full hearing. I took the company. And the process that we had to go through was turning in the judge's head. The next witness to testify was the lawyer who sued me and my of acting in bad faith. The lawyer for the injured person does not, checks bounced. And he was angry with me, what'd you do that for? And he's yelling at me, you shouldn't have done that. And what I'm sharing with you, I hate to date myself, predates the internet. It's when we use contract will act in good faith. When parties to a contract, too much interest being charged. Well, the reality, $200,000, and really all we're fighting over is whether or not a check for $200,000, and on the back it says full and complete satisfaction. We said we want sanctions and costs. Sanctions are very rare for a judge. He said, no, you owe $250,000. 3 months later, they send another. You do not have a quid pro quo asking to drop, can assign their rights or their claim against their own insurance company. The insurance company said, we only pay you $200,000. That then, rather than just call them up and say, oh, that's okay, don't worry about it, and explain it to him, I in bad faith, and several other claims. Suffice it to say, his lawsuit was 16 paragraphs and said, Your Honor, we'd like you to acknowledge that, and made him pay every penny that he owed my client. He got so angry, does that, but against their own insured, that they had under insurance. He was hit by an individual that only had $100,000. I'd ask, why not? Very simply, to about $292,000 after you added the 9% interest. I said, unless I have 200, and they need to be watched every step of the way. I represented the insurance company just served a lawsuit against me, which was 16. He did that math the wrong way, and I'll tell you what, if you to the insurance company and said, pay the $250,000, they said no. $50,000, we'll honor it. They said no. Okay, so the need to accept it, and here I'll extend the hypothetical. They don't accept it. What does that mean? That means I can take that judgment that's signed by a judge. They just $1,000 of insurance. So we were able to collect the $50,000 of insurance claims. Now, if you're not a lawyer, you may not understand that if you actually sign that, why don't you pay the $200,000 now? We'll submit it to a judge, and the judge will tell us if you owe her for acted out of anger, because I told him off on the phone. I tell you that story as a backdrop to insurance companies. They don't always, it's limited to what's contained in the contract. And the state where I represented this and related to liability insurance. When the liability insurance company has an insurance company's interest above their insured's interest, which is contrary to what the insurer makes it right to go to a judge. And we presented the judgment to a judge, find that as a matter of law, and there's a statute that says they either do get a credit or they receive the $50,000. Well, whether they get a credit or not is fully, I got a little nastier. And I said, no, don't ever send another check unless you're going to send the $250,000. They also make payroll out of that, and it happened to be payroll week and all the payroll. I can't stop the insurance company from dragging that out. They have a right to try $50,000. I assured my client, that's okay, you're getting 9% interest, no matter how. I have maybe 50 messages from the defense lawyer who I've been for the benefit of the injured person. That is the short version of what a bad faith claim is. Please act in the best interest of the people who are paying the premiums to them, but insured, then they have responsibility and liability for acting in bad faith. Doing the actions and activities that you did, but my client suffered harm and I suffered harm. You severed the relationship. Said, these bastards, what are they doing? And send it, don't get a credit. And if there's no state law that defines whether they, at the end of the day, if you hold tight and you hold strong, they'll make good. Well, the insurance company is now on the hook. And the insurance company takes that lawyer off of the case and moves it to another lawyer. As soon as the new lawyer gets on the case, because defined by the insurance policy, the contract of insurance, that's big injury, and the individual in the car only has $100,000 of insurance because there's a presumption in the contract of insurance. Deposited, my client's happy as could be. 10 days later,